What's up, everybody? Welcome back into another video in a week we thought would be slow, but instead we have our first in-court hearing that was actually streamed for us to watch in New York, which I guess is unusual. I don't know if it's just going to be this part of the proceedings or what, because people told me this doesn't usually happen in New York, but we have a Luigi Mangione hearing and citing. We get to listen to what his lawyer has to say about the perp walk, about the arrest. She had some pretty nasty comments to make about the mayor and how law enforcement and the prosecutors are handling this case, how they're treating Luigi Mangione, and the context surrounding the case for which he is presumed innocent at this point, but is accused and now charged. We'll talk about how he pleads. We'll talk about which case is going first, state or federal, New York or Pennsylvania, because we find that out in this hearing. And of course, I'm going to ask my dad a bunch of questions. We're getting a lot from you, from social media and online, that we're going to answer throughout this video. So sit tight, hit that like button, and let's get into it. So I've been doing a bunch of other stuff today. I haven't really seen a lot about this or why it was streamed. Did you see anything about why this particular hearing was streamed? I've seen other New York cases weren't. Obviously, the federal case is not going to be. This is just for the state New York case. That's the hearing we are going to watch together. Did you hear anything around the context of why it was recorded?
No, and I went online and looked, and nobody raised any issues. Or again, I don't know. Maybe it's the trials they don't allow to go on TV. Maybe hearings are okay. I don't know, but no one jumped all over the fact that it was online.
Yeah, I don't understand that either. And I thought there have been other cases where for sure even the hearings I didn't see clips of, but I don't know if it's, some will be, some won't. I don't know if it's something they're doing specifically for this case. I'm sure if any commenters or people watching know, they'll let us know in the chat. But let's jump in. Let's listen to this hearing. And there's a lot to break down and a lot to take from just a 13-minute hearing because this was kind of the first opportunity for lawyers to put things on the record. And especially defense lawyers love to put things on the record, especially when they know there are eyes watching, there are people writing about this, and even cameras in for this hearing.
24, charging with the crime of murder in the first degree and other related charges. Have you pleaded this indictment, sir? Guilty or not guilty?
Not guilty.
People.
All right, so let's just start with that. First off, I want to start with who's at counsel table. It is his attorney, Karen Friedman Agnifilo, and her husband, Mark Agnifilo, over to the left of the screen as I'm looking at it. And that is P. Diddy's lawyer. And we know there are federal charges in P. Diddy's case. We know that there are federal charges and an indictment likely coming in Mangione's case. And we talked about, his wife has a lot of state experience, but clearly this is the law firm, so it seems, that's going to represent him on both the state and federal charges in New York. They are both there together to have his plea here at the arraignment. He is pleading not guilty. And that's from all reports and from me watching this video, unless there's more than this, those are the only two words he says throughout this hearing.
Your Honor, we have a copy of the indictment, notice of immigration consequences, as well as rap sheet. I believe the court has it. We give the court an extra copy and one to counsel. Does the court wish that we be heard with respect to bail?
Well, what is the situation with the federal authorities? They have a security order on
As we
So the judge asks the question, what is the situation with the federal authorities? Why would the judge be asking that question at this hearing?
Well, because he now talked about bail, and if he's not in state custody, then the bail's kind of irrelevant because the feds are going to hold him. So it depends on who's going to hold him and where he's going to be and who's going to have jurisdiction over him. And that's what the judge he's fishing for that. And he's trying to figure out what's going on. And we'll learn that, that's explained more as we go on.
Understand that we have primary jurisdiction, and we have been informed by the U.S. Attorney that they intend on allowing us to try our case first. So with respect to...
So that's a big revelation. That's something we weren't sure of. And that's also interesting to me. So the feds said that they are going to allow an interesting conversation. I believe that's what he said, allow the state to go first. I'll back it up just so we can hear that language and then we can discuss it.
Allowing us to try, warned by the U.S. attorney that they intend on allowing us to try our case first.
So the feds are going to allow the state prosecutors to try their case first. Why do you think that is?
Well, it's the right thing to do because he's right when he also said the word primary jurisdiction.
No,
They were the
I don't think
first.
we've gotten there yet, but that's fine.
Yeah, they were the first ones to take him into custody. So in normal cases, and we said this in prior videos, in normal cases, the first people to take him into custody, those are the people that have the primary jurisdiction to try him first. So the state normally would. Now, the feds, they could usurp that because federal courts could usurp it. They could issue writs and they could take him and will take him into custody and not let the state have him until they try him. But in normal cases, the way it works, and they do it by agreement, the state would try it first in this case because the state had him in custody. If you remember back at the extradition hearing, he was released to the New York Police Department. He wasn't released to the FBI. So the New York Police Department had him. They transported him here. He got off an NYPD helicopter. So they had him first.
And usually that's how you determine who goes first, right?
Right.
And so from my perspective, I like the language that he used, that the feds are allowing them to go first, but that's a big question to answer. What do you think is now when you want to kind of talk about the difference as far as like, if it's better for a criminal defense attorney to go state first or federal first, better for a prosecutor? Do you want to save that for later?
We can save it until he talks. They'll talk about discovery later on here, and we'll talk about that then.
So with respect to whatever goes on there, as the party with primary jurisdiction, the trial and the sentencing will take place here prior to anything that takes place in the federal system.
So that's where he said primary jurisdiction, exactly what you said. We've already watched this hearing, obviously, and have our notes on it. But so the primary jurisdiction is exactly how you explained it. First came here.
Right. And now the interesting thing, though, he said, it doesn't always happen this way. He said the trial and sentencing will happen first. That's not necessarily something that has to happen. Trial, yes, but there's no need to wait for the sentencing. The feds could try him while he's awaiting sentencing in the state case. So that's something, again, these are agreements that are happening between these offices.
So what you just said, the answer is it's fine if we take custody today.
That I'm not sure, because Your Honor signed a writ in which it says that we're going to return the defendant to federal custody. So I think that would be step two. I do think that logically, as the party with primary jurisdiction, the custody should be here. But I asked the court, in light of the court signing the writ indicating that we would return him to federal custody, that be done at a later time.
So what are they
I think
talking
that,
about?
yeah, writs. These are extraordinary court pleadings or documents or motions. You know, we've all heard about writ of habeas corpus or writ of mandamus, but there also are writs that transport prisoners between sovereigns. We talked earlier, the federal government is a sovereign. The state of New York is a sovereign. So therefore, in order to transport him back and forth, there has to be a legal document or a contract between the authorities. In this case, state judge issues a writ saying, we want this man from federal custody taken into state custody so he can appear in court today. We guarantee you that we're going to return him to federal custody. And that's important because the feds don't have to give him up. The state court does not have a jurisdiction to order federal authorities to give him up. So there was an agreement there that he was going to go back. And that's what the prosecutor is talking about, is that the judge signed a writ saying he's going back to federal custody because he was in the Brooklyn Metropolitan Detention Center. And that's where he's being held right now. Which
is federal is where he's at right now.
Right. So he's in federal custody. So that's why the state judge has to issue a writ guaranteeing he'd be returned to federal custody after this hearing.
So basically, yeah. So he's in federal. They want to put him in state, and then they said they'll return him back to federal. But what if the feds say no? You have to keep him in federal custody. they still can go forward with the state case first if that's what the U.S. attorney says. So it's still possible for him to be held in federal custody pre-trial, the state to try their case, and then to have the feds try their case.
But it'd be very awkward because you'd be having issue these writs over and over again every time he's transported back and forth and back and forth, and so it causes a lot of time, money, and it's just awkward to do it like that.
And every jurisdiction is a little different, right? Because some of our clients that are in federal custody stay at the state jail here, and sometimes that's the closest one to the courthouse, and it's just the easiest for transportation. So all of this is really done in order to not make it a logistical nightmare during a case, especially for a client that I'm going to guess is going to get no bail or very high bail of some sort, but I would assume no bail at all. And so they're going to have to be transporting him back and forth for every hearing, for the trial, for things like that in this case.
Right. Here locally, we don't have a federal detention center.
So they got to pick one around.
Right. They contract with these county jails to hold federal prisoners. New York has one. Miami has one. The big cities have their own federal detention centers. But the smaller locations and jurisdictions, they contract with the county sheriffs.
Well, I've been through this before, and if you do that, they will rid him right out of his term. So I don't think I'm going to do that. But if you work it out with them.
He said he doesn't think he's going to do that. So the judge isn't going to step in and do it, but he said you can try to work it out with the feds to get him into state custody.
Right. In fact, he specifically said that the feds are going to rid him right out of here if I don't send him back.
We would take custody rather than us bringing him back for any proceedings. That would be great.
We will make every effort to accomplish that, Your Honor.
So we are getting some questions in live, but while we're recording this, and Night Owl asked, why are those cops hovering over him at his head while he's shackled? Don't think I've seen that before. And what about the judge in a possible conflict giving her husband's occupation? I don't know the judge's husband's occupation, but why are the cops huddled around him? Why are they so close? Why so many cops? Why is this how this courtroom is set up for this hearing?
Well, you've got a couple of things. One, if you got the high security, he's a high value individual, so they have to have high security. The other is to protect him. There are people in that courtroom on both sides. There are people in that courtroom that, obviously, he's got a lot of, I don't know how much, but there's been a lot of press about his public support. There could be people in that courtroom that want to have him or help him escape. So they have to keep watch on him, and they have to keep a separation between him and the gallery behind it.
Yeah, and here we have red dot criminal defendants that are the extremely dangerous ones. He's probably in that category, but also being a high profile case, like you said, even for his own protection, for the judge's protection. We just did our wildest moments of 2024 where the criminal defendant jumped the bench and attacked the judge. We don't want anything like that happening. We don't want anybody jumping and attacking him. So the protection is twofold.
Right.
But there should be some kind of detainment, and we know that.
Yes.
As their security order changes, there should be some mechanism that you provide here.
Absolutely.
And then you do that. All right, is there any further?
Yes, Your Honor. We'd like to make a record if that's okay.
So before the defense attorney makes a record, did you have something you want to say first?
Well, I wanted to say, notice her words. She's just saying this stuff just to say it, to get her words typed down on the transcript. It's going to have no impact on this hearing, but she wants to make sure the transcript says the words she wants to say for future reference.
Yeah, and I think that she wants the world to know what she's about to say. And her comments, with 100% certainty, let me know she is going to be following this case online, seeing what people are saying about it, what they're posting about it, what the sentiment is, what the comments are, what analysts are saying about it. The bigger channels and bigger analysts, like Fox and whatever, CNN. She's probably going to be watching those channels to see what the general sentiment is around her client and around this case, as she should. It's a tool in her tool belt that she's going to be able to use and kind of keep her finger on the pulse of the public. But without a doubt, the number one question that I have gotten on social media, even before this video started and right now, coming in from Michael D.H. Sue and from other people from Facebook, did Luigi Mangione's attorney dress to match him on purpose? Is it normal for a defense attorney to dress like their client? Never seen anything like that before. I know this is a silly question, but I'm honestly curious if it was purposeful that she dressed like her client. I know I have my thoughts, but what are your thoughts on that?
I don't think so. I mean, I really don't. I really don't think she did. Now we'll see. We'll take a look at other hearings if this, becomes a pattern. But I just can't imagine there's any reason why she would.
Yeah, no way. Well, I mean, I would be shocked. There's no way I think that she dressed like him on purpose. Although, I mean, I wonder if she brought him his clothes. If she did, she knew what he was wearing. So it is kind of weird. But his family could have brought his clothes. He could have got his clothes from somewhere else. And she happened to dress like this morning. I would be shocked if she matches him every hearing. But who the heck knows? And by far the most asked question so far on social media. All right. So let's take a listen to the words. She wanted to make sure she got on the record. And like you said, kind of irrelevant to this hearing. This is not an opportunity really for her to make an argument. They're not arguing bail at this point. He's just there to plead not guilty, which he's kind of already done. But let's hear what she wants to put on the record.
With Your Honor. First, we'd request immediate expedited discovery in this case. The people have had this case for about almost 3 weeks, and that's more than enough time to gather as much information as they can give to us, especially now that we have two proceedings that we have to answer to, one of them being death eligible. So we are requesting.
So she makes a couple comments there. She says she wants expedited discovery, and they have so much going on, including multiple jurisdictions with charges, including one that's death penalty eligible. And that would be the federal charges. Is this where you want to mention the discovery stuff, or you want to wait?
Well, we talk now because, again, this is just for her to put this stuff on the record. She was the chief assistant of this office. She knows that 3 weeks is not a heck of a lot of time for, 200 and something hours worth of video they probably took off of CCTV. She knows all that. She knows, and when she sits there and says, this is for public consumption. Oh, they've had it for 3 whole weeks, so they should be able to give it to it. Expedited discovery. What is expedited discovery? She's going to get the discovery when the rules say she's going to get the discovery. There is. I read the rule in New York, and there's nothing in there about expedited discovery. But she just, again, I think public consumption has a lot to do with those statements. And in case later on, if anybody ever says, "Oh, you slow walked this case for trial," she can say, "Oh no, it wasn't me that slow walked it. I tried to get discovery early, but they're the ones that took so much time getting it to me."
Yeah, I think there's nothing really expedited about this case. Like, there's no reason to expedite this case. If he wants a speedy trial and he doesn't want to waive his speedy trial, but instead wants to demand it, there are rules and timelines in place for a speedy trial, and they will stick to those rules and timelines. I can't see an extraordinary reason for the judge to push this case or force it to go any faster. But what you talked about at the beginning of the video, which I really hate referencing things that we're not talking about, but about why it's different between federal and state. Do you want to talk about that now? We're talking about discovery.
Sure.
So go ahead and explain
All right.
why do you think it's better for a defense attorney for them to do the state case first, which is what's happening here.
Okay. If I was a defense lawyer, this is what I'd want. I'd want the state to go first. The reason is you get things, you get evidence in the state case you're not going to get if you were just doing the federal case. For instance, in New York, you get a list of witnesses. You get witness statements. You get 911 calls. You get all of that right in the beginning of discovery. At the U.S. Attorney's Office, if you're doing a federal case, you never get a witness list until the morning of trial. You never get that ahead of time. You don't get witness statements until you ask for it at trial. It's called the Jenks Act. It used to be you never got statements till they finally passed some act that said, all right, morning of trial, you can go ahead and get the statements. So all of this advanced information she's going to get from the state, that's because it's a state case. So she's going to be ahead of the game. And the feds, if they were just prosecuting it, they would rather she didn't have the witness statements or the witness list. But she's going to have it from the state case. So that's going to also give her an advantage in the federal case if they're tried twice. Also, I would rather it was if I was a prosecutor, the federal case, because there's a death penalty in the federal case. If he is convicted and if he gets the death penalty, that goes a long way to plea bargaining what's going to happen in the state case. So maybe he'll never go to trial in the state case, and they'll just reach a plea bargain. The more serious sentences in the federal case and the more restricted discoveries in the federal case. So that's where a prosecutor would want it. The defense lawyer would want the place with the easier sentence and the place that has the looser discovery, so you get and see more in preparation.
And a lot of people understand that the rules seem to favor the prosecution. This whole process favors prosecution, even state cases. We can't explain enough how much that levels up when you go to federal court, how much harder it is
Right.
as a defense attorney in federal court, and why the conviction rate is even higher there. All right, she has a lot more to say. So we're pausing this a lot just because there's a lot of explanation, a lot of questions coming in, but she has a lot more to say that we need to discuss.
Requesting that we get immediate discovery of the New York City Police Department and FBI and federal and state documents. And the second thing I want to make a record of, Your Honor, is I'm very concerned about my client's right to a fair trial in this case. He's being prejudiced by some statements that are being made by government officials. Like every other defendant, he is entitled to a presumption of innocence. But unfortunately, the way this has been handled so far, his rights are being violated. And as you know, Your Honor, there's a wealth of case law guaranteeing his right.
So she argues right to fair trial, and she says his rights are already being violated. So we'll hear why and how she thinks that.
The other thing to notice too is she had this all written out. This is a speech. If you see, she's turning the pages as she's reading her speech. So this speech was all written out before she even got there. Also, she talks about the FBI. The state prosecutor has no right and no authority for any FBI information. Whatever the state prosecutor gets from the feds, it's a gift, because she can't require the state to turn over FBI information to her. So there's kind of a conflict, because she's trying to put the FBI information on the onus on the state, but the state prosecutor doesn't have that authority.
Yeah, and that happens in a lot of cases. Defense lawyers trying to get stuff from them. But if the FBI did testing on a state case, usually that is discoverable and they can get it.
But it's a gift. But there's no requirement that they just give it to them as a gift.
And we've seen that in the Koberger case, how the defense is like, where is this stuff? And the state's like, the feds tell us this is all they have, Judge. There's not really much else we can do. The judge can't force the FBI to come sit down there and turn over documents that they say they're not going to turn over.
Right to a fair trial, but none of the safeguards have been put in place yet here. In fact, it's just the opposite of what's been happening. He's a young man, and he is being treated like a human ping pong ball. Kind
of awkward motions, right? Like she's like, he's a young man, and then touches his shoulder like she's, again, preparing a speech of some sort. Like you said, that was kind of awkward.
Happening. He's a young man, and he is being treated like a human ping pong ball between two warring jurisdictions here. These federal and state prosecutors are coordinating with one another, but at the expense of him. They have conflicting theories in their indictments.
All right, I want to talk about the conflicting theories. So first off, she says he's being treated like a human ping pong ball, but he's not like bouncing around all over the place. He got arrested in Pennsylvania, where allegedly he fled and then sent back to New York, which is exactly what always happens. It's not like he's been sent to 20 different places that I'm aware of. Number one. Number two, conflicting theories, in my opinion, is the feds are not charging him with any terrorism of any sort, but they are charging him with stalking, and the state is charging him with the terrorism count or enhancement, whatever you want to call it. So she's saying those are conflicting theories. Do you agree with that, or do you disagree with that?
First of all, it doesn't matter if they're conflicting. They're allowed to try him on whatever theory they want to try him on. But here's what she's talking about. Again, I think terrorism is the idea that he's attempting to influence a group of people by his criminal act, a group of people. In the federal indictment, he's stalking one individual, and that gave them the jurisdiction because it was stalking across state lines. So in the federal case, they're talking about one individual, that they only have to prove this one individual for stalking. And that's their whole case. After that, stalking is in every one of the charges after that. But in the state case, we're talking about a group, multiple people being influenced. I think that's what she's talking about when she's talking about different theories.
Right, I agree. Stalking versus terrorism, which is by definition one person versus a group. But
right,
I do think that, again, you're right. Doesn't matter if they're conflicting. But just because they're going after stalking an individual doesn't mean the feds won't also argue he did this because he hates the insurance industry. He did this because he's making too much money. That doesn't mean they're not going to argue that as part of the facts of their case. It's just not an enhancement or a charge or statute that they used in charging him. And we all know superseding indictments are a thing. Charges change, which is why, again, this is kind of a nothing burger to say that they have conflicting theories, but it sounds kind of good in the public to be like, oh, this is so unfair, conflicting theories. They're coordinating against him, which again, that's what prosecutors do, right? Prosecutors are going to coordinate against, they're going to do everything they can to hammer you and convict you. And state and federal prosecutors commonly work together on cases and try to do everything they can to pile on for as much leverage as possible, which is what we said from the jump. And I don't disagree with a lot of what she's saying, right? I agree with what a lot of what she's saying, but what my pushback would be, that's how the system is.
Wouldn't you love to ask her as chief assistant, how many times did she call the U.S. Attorney's Office herself and coordinate a prosecution? I mean, she probably did it 1,000 times, but she's standing up here making the pitch for the public.
Yeah. And I think that there's nothing wrong with it, right? There's nothing wrong. I really don't think there's anything wrong with it. I can understand if you want to have the discussion about the two sovereigns, should they be able to charge him federally and state? I could get behind that argument maybe is unfair, but as it sits right now, they're allowed to. And so there's nothing nefarious going on that we know of just because he's being charged in two different jurisdictions, 3 technically.
And they're literally treating him like he is like some sort of political fodder, like some sort of spectacle. He was on display for everyone to see in the biggest staged perp walk I've ever seen in my career. It was absolutely unnecessary. He's been cooperative with law enforcement. He had been in custody for over a week. He waived extradition. He was cooperative at all accounts. There was no reason for the NYPD and everybody to have these big assault rifles that, frankly, I had no idea it was in their arsenal. And to have.
All right. So what are your thoughts there while I get up a picture of the perp walk?
I don't know. I find it hard to believe that the former chief assistant of the state prosecutor's office did not know they had those kind of weapons in law enforcement. I mean, maybe it's true, but it's just hard to believe.
I'm trying to pull up a picture of it. So, I mean, I have no idea what she knows about pictures or whatever, but I'll just share my whole screen here. So these are the pictures of the perp walk. Literally looks like Gotham City. The mayor's there. They have all these big guns and everything like that. And it's just, I mean, it was quite a spectacle. I do completely agree with her. Again, nothing illegal about this. Morally right, wrong, whatever. Nothing that she's going to win an argument about this. This doesn't prove anything. This isn't going to make the judge say this doesn't mean he doesn't have a fair trial. First off, for sure. Doesn't mean that. She may argue, I guess, if they want to change the venue at some point, that having the mayor walk behind you with all these officers with these big guns is convicting him in the court of public opinion. No way she can find an unbiased juror. But in which city in the world does the news cycle turn over quicker than New York City? They're going to have something crazy to talk about in a week, I'm sure. But from my perspective, I get why she's doing this, right? Because this part, people were outraged. It was a bit of an eye roll, like they went overboard. I've never seen a perp walk like it. I don't have quite the lengthy career that she does or that you do. She's 2 times me, you're 2 times her. But I mean, you said you don't see a lot of perp walks like this either, especially when the mayor, who's under indictment as well, is standing right there behind him as a show of force, which she's going to mention exactly how she feels about that. So what do you think about her actually mentioning this in open court on the record? Do you think it's just all part of her kind of game plan to say this to the public?
That's exactly what I think it is. I think that there's been so much bad publicity that she is trying to combat that bad publicity with what she's doing today. And that's all it is. She's trying to see if, she can, make things a little bit better out there for the average juror that's going to come eventually and face her, that she's going to have to select for this trial. So that's what she's doing, is she's making her case for his being treated unfairly, and he's just such a poor boy that they're all just ganging up on him.
Yeah, I mean, I don't really have a huge problem with it, and I think that she knows there's public support for him as well, and to feed into that, to fuel that fire is probably not a bad thing for her from her perspective to get more and more jurors on that side. What was the stat you told me about young people in America thinking that he was justified or something?
41% thought that it was justified, and young people.
Adults.
And it just, that number shocks me.
Yeah.
But I've also got to say with her, one of the last comment, I'd rather she did it in court than at the courthouse steps.
Good point.
You know, I'd rather, if she was going to make speeches like this, do it here. So it's on the record and everybody hears it, rather than, you know, doing little press conferences, which, you know, she may do. I don't know. But this is a better way to do it.
And I like that with this, you have the candor that you have to have with the court. Your rules of ethics are in place. What you have to say, what you say in court has to be true, you know, as an attorney, and all those rules and are in effect while she's in court making these arguments. So I like that point. That's a very good point.
Have all of these, the press there, the media there. It was like perfectly choreographed. And what was the New York City mayor doing at this press conference, Your Honor? That just made it utterly political. And as Your Honor knows, under Lauro v. Charles, the Court of Appeals for the Second Circuit has held it to be clearly established that the staged perp walks to the media, unrelated to a legitimate law enforcement objective, is unconstitutional. And I submit there was zero law enforcement objective to do that sort of perp walk. There's absolutely no need for that whatsoever. And
so, like, what does she expect the remedy to be with that argument? You know, it's
Well,
like,
notice she didn't say any remedy. She didn't say, she said, the court said this was terrible. But did the court do anything about it? No.
And frankly, Your Honor, the mayor should know more than anyone of the presumption of innocence that he too is afforded when he dealing with his own issues. And frankly, I submit that he was just trying to detract from those issues by making a spectacle of Mr. Mangione, and there are consequences.
she says he's dealing with his own issues and talking about the
Right.
mayor. So that, I mean, that's shots fired. We're taking on the whole big bad government. Everybody's against him. And frankly, we've seen in other criminal trials where they will put up there the mayor following behind. They'll be like, they want this guy. They were zeroed in on this guy. They were going to make sure it was him, especially if they're going to argue they planted evidence, and they're going to have a lot of fodder for that. Look at how many law enforcement officers, look at all these press conferences they're doing. Look at the mayor. Look at how they walked him out like some Batman villain. They're going to make him look, like you said, you know, the poor young boy over there that the big bad government is against. And they're giving her a lot of fodder for that argument already. And we're 3 weeks in.
They are. And again, everybody should keep in mind, if the elected mayor of New York cannot be controlled by the state prosecutor's office. So, you know, I mean, they're different elected officials and they can't control each other. So whatever the mayor does, he does.
Messy Macy asked, will there be a gag order put in place? Would it have to be for state and federal cases, or could it just be for only one?
Well, you have to have different jurisdictions. So it'd be a federal judge if they did a federal gag order and a state judge for the state gag order. I don't hear anybody moving for one yet. And I'm kind of wondering, she may not want one. You know, she might not want one because maybe, you know, she wants to say stuff because her clients, let's face it, everybody probably thinks her client's guilty. It's whether or not people think it was justified or not. I don't think anybody's doubting that he did the shooting. So she may not want a gag order.
Well, they still have to prove it, right? They still have to prove that, number one. And number two, are you okay? All right. So they still have to prove that it was him, that he did it, number one. And number two, this is New York City. This is not Idaho. And in New York City, they're less likely to ask for a gag order, in my opinion. They're more likely to deal with stuff like this exactly like they're dealing with it. So there could be a gag order. And when he said that nobody has moved for it, he just means neither lawyer has asked for it. The judge hasn't forced a gag order of any sort. She's making these arguments that he's not getting a fair trial based on him being ping-ponged around and prosecutors working together against him and this perp walk with the mayor. She's making those arguments that it's not a fair trial, but she's not saying the media coverage is making it an unfair trial at this point. And that's really the argument she would have to make in order to push for a gag order.
To detract from those issues.
What?
No, go ahead. And again, later on, when she tries to move for change of venue, you know, she's going to have to prove that the public was, you can't get a fair jury. And like you said, New York City, there's been huge statistics, even in smaller jurisdictions, about how few people even watch the news. So I think you'd be able to find a jury in New York City that's not swayed by the news.
Do you think she is going to move for change of venue?
If I were her, I wouldn't. I don't know. She is going to do the things that lawyers do to protect the record, just like she's doing here. She may move for a change of venue just to make sure the record is protected, so she has that motion. Later on, we'll wait till later on when the prosecutor talks about some things, but she's going to file all the motions that you can file in this case, because that's what she has to do to protect her record. And she will eventually file a change of venue.
So I think she wants to have, whether she files change of venue or not, I think she wants to do it in New York. I think this is her stomping ground. This is what she knows. I think this is where he's going to get the most public support. I think that, usually change of venue, you want to go from a small town where all anybody cares about is this case to a bigger venue. There ain't no bigger venue than where they're at. So I don't really see a lot of opportunity or upside or legal reason to change venue in this case.
No,
this is where it happened. This is the community that was affected. This is where the case should be tried, in my opinion.
By making a spectacle of Mr. Mangione, and there are consequences to this. He has a right to a fair trial, and I just want to put on the record statements that the mayor made publicly about my client. Nothing saying alleged, for example, and he said, I wanted to send a strong message with the police commissioner that we're leading from the front. I'm not going to just allow him to come into our city. I wanted to look him in the eye and state, you carried out this terrorist act in my city, the city of New York that I love. And he wanted to show symbolism. Your Honor, he's not a symbol. He's somebody who is afforded the right to a fair trial. He's innocent until proven guilty. And the mayor was talking to jurors, future potential jurors that elected him. Those are the people that elected him, that he is talking to and calling this man a terrorist. So, Your Honor, I just want to...
What do you think about that? The comments made by the mayor, she says he's speaking directly to jurors. Again, seems like a good evidence towards a change of venue, the presumption of innocence, looking him in the eye. What do you think about that?
Two things. Still, she has to prove that she can't get a fair jury, regardless of who he's talking to. And, like you said, there's no better jurisdiction probably for this case than New York City. And a lot of judges, you and I know, how many judges would have let you sit there and give this speech? A lot of judges would have cut you off and said, do you have something to say about the hearing today? This hearing is for a guilty or not guilty, and to talk about that. So if this has nothing to do with pleading guilty or not guilty, save your speeches. But this judge is just letting her go, which I'm kind of surprised. I don't know many judges that would let her go on like this.
Yeah, none that I have ever practiced in front of. But what I will say is this seems a lot longer than it is because we're only 6 minutes into the entire hearing. We just keep pausing and talking about it. So we've been talking for 35 minutes. She's only been talking for about 3. So it's not as long as it feels because we keep pausing it every 10 seconds, it seems like. But there's just so much that I want to break down from this, including she's bringing up comments that the mayor's making in the media. It would be very interesting if the prosecutors brought up the comments that she made about this case prior to being hired. That seems like there's a lot of evidence against him. He only has insanity defense, which again would just be an interesting discussion if we're just giving speeches about what people have said in the public eye so far.
Make a record of this and put everyone on notice that this has to stop. And my client is entitled to a fair trial and the presumption of innocence. And we're going to fight these charges, whether it's in the state or federal, to the fullest extent. Thank you, Your Honor.
All right, well, as you know, I have very little control of what happens outside of this court. But I can guarantee you, as I guarantee every defendant who comes through these doors, the defendant will receive a fair trial.
It seems like the judge's mic is off.
Yeah, I don't know what the judge said was, I can't control what happens outside these doors, which is basically his way of saying that's not really relevant to what we're doing here. But what I can say is inside these walls, I can guarantee he's going to get a fair trial in front of me, like I guarantee every defendant that comes before me. So that's basically what the judge said. Exactly what we've been saying. It's like, okay, I can't really do much about that, but this is what I can do.
That's the jury, if that time comes, or when that time comes. But yes, you should expedite discovery.
Your Honor, excuse me.
He said, yes, we should expedite discovery, but I'd be very surprised if we had some kind of order that discovery has to be done before any of the normal deadlines.
No.
Basically, he's just saying, do it as quickly as you can.
The discovery in this case is voluminous, to say the least. I have never seen a case with such volume of evidence, aside from the issue of the quality of the evidence. I suggest to counsel, because we have a discovery portal, but given how much evidence there is against this defendant, it would be smarter if counsel could provide us with a 2 terabyte external drive rather than rely on the crashing of the portal. With respect to statement and identification notice, we will be getting.
He's like, Judge, we're going to turn it all over. We're going to turn over everything we have. But just believe, as more things come in, they will continue to pass those things over in discovery. I'm sure we're going to get moments where the defense argues they didn't give us this, they should have. They're delaying. They got to give us this, Judge. That happens in just about every single case.
And I think a lot of people don't know this, so just an educational thing. When he's talking about the portal, what he's talking about is there's a lot of people know what Dropbox is, and it's where they dump stuff on the internet into a box, a virtual box, so that defense lawyers can access that box and get the discovery out of it digitally. And they have that in New York, as they do in most jurisdictions now. So they have a digital box where they were going to dump everything. But this is so huge that he's worried that the system is going to crash if they dump everything into the digital box, which is a portal. So what they want to do is an external hard drive, turn it over to the prosecutor. They'll download everything digitally to her and hand it back to her. So I guess just to explain what a portal is versus getting a 2 terabyte. By the way, 2 terabytes is a lot of information.
Yeah, hearing you explain a portal or Dropbox was not on my bingo card today.
Giving that notice within the next 15 days. We're preparing an ADF. We'll do our best to expedite discovery, but I'll say that with redactions and with the volume of it, we're hoping to do it as best we can under, this is not a usual case in terms of the thousands of hours of video tracking and the like, and the fact that we're not only responsible for discovery in this county, but in Altoona, where the arrest was made and where several officers were involved. And we're in touch with those people, and we're going to get everything counsel's entitled to.
People, I'm sure, are going to have questions. Why are they responsible for the discovery in Altoona, which is in Pennsylvania?
Right, because if they want to use it in their case, which, come on, I mean, that's where they got the notebook. That's where they got the gun. If they want to use it in their case, they've got to turn it over to the defense. So they've got to get all that material from the Altoona, the local police in Altoona. They've got to get it so they can turn it over to the defense.
I thought he was even saying the opposite. Like, we've got to also provide the Altoona prosecutor's office with everything that we have, because they're proving their case with the Mark Rosario stuff at the hostel. So they've got to turn it all over so that they can give it to the Pennsylvania defense lawyer.
Right.
So they
it goes both ways. You're right.
Yeah, they got to send discovery all over the place. As
to other issues, I think a 30-day adjournment to see where we're at, and to, of course, counsel's aware of the various notices. We have notices as well. I take it that the counsel will abide by the statutory limitations on their notices with respect to any notices they believe to be appropriate. As to counsel.
Yes.
Notices. What he's talking about there, I think, is the notice of an insanity defense. I think that he is specifically making sure he makes a record that he told them, don't forget your statutory notices, because if he's going to have an insanity defense or any kind of diminished capacity defense, you've got to give the state notice of it. If you've got any evidence, you've got to give the state notice of it too. You have a reciprocal responsibility to give the state all these notices and all this information. And I think that's what he's fishing for, is to find out what their defense is going to be.
Record on the mayor basically repeating what the mayor said. I don't know how that advances the ball. We will comply with our ethical obligations with respect to trying this defendant's guilt in this courtroom and this courtroom alone. Thank you.
All right, so,
All right. So basically, the video starts to like geek out near the end and speeds up while they're scheduling the next hearing. But some other questions came in on social media about the rapport between the lawyer and her client. What did you see? What did you gather from that? Any expressions or mannerisms that would tell you how the relationship looks? It's kind of hard for us to know. You can't really tell. To me, it looked normal and comfortable, but did anything stick out to you?
Well, he was watching her while she spoke, and he seemed comfortable, and he didn't make any negative facial. So he was happy with the things that she said. He wanted her to say those things. So I think they're probably working it out pretty well. It
And
seems that way.
also, if you remember in a prior hearing in Pennsylvania, he spoke out. He said some things on his own. He had to be shushed by his other lawyer. None of that here. He just said not guilty. Looks like he's taking counsel's advice, which is always good when you are a criminal defendant in this situation. Any final parting thoughts or words about what's next? What do you expect to see?
Well, a couple things about that hearing I think were interesting. And again, these are things that were reported. None of his family members were in the courtroom. Normally we have family members of our clients sitting in the courtroom, but none of his family members were in the courtroom. Number two, apparently there was a group of ladies that gained access to the courtroom that were fans of his and that went through security and sat in the courtroom. And they've already hired consultants. There was a jail consultant that was there in the courtroom. So, they're getting geared up. It's going to be, you think about how many hours of tape they're going to have to listen to and CCTV they're going to have to listen to. But it's starting, and in 30 days, we'll see. I think the purpose of that hearing is to find out, has the state turned over discovery to them? How much discovery has been turned over? How much is left to be turned over? And we're going to have issues of, we've talked about in many other cases, Brady information. Is there anything that goes to his innocence, or goes to the negative cross-examination of witnesses? Have they turned all that over to them? And then we're going to talk about the notices, because do we have any notices? Do we have any motions about change of venue? Do we have a notice of insanity defense? Do we have any alibis? Any of those things. Plus, in New York, the state has to give a certificate saying they've turned over everything to the defense. And whether that certificate is going to be able to be accomplished in 30 days will be interesting to see.
Yeah, I think we're in for a lot of different legal maneuvers in this case. And I think that they're going to be making a lot of comments in the press and a lot of comments on the record or whatever it may be, to let us know exactly what their theories are and why they are. And I think they're going to be following what the public is talking about this case, the lawyers on both sides. So we'll see how that affects the case, if at all. But that's all we got. So this will probably be it before Christmas Eve and Christmas. So to everybody watching and listening, Merry Christmas. Thank you so much.
Merry Christmas.
For another year. Yes, we will be back probably either later this week or next week to talk about different cases and things and our plans for the next year. But you guys are the best. Thank you so much for joining us, Dad. Thanks for being here. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.